I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Good afternoon. I'm constitutional attorney Catherine Henry. Welcome to this week's episode of Restore Freedom Weekly. Today's topic is unlike every other topic that we've been covering since we started this show, but it is a vital, essential, very important topic that we need to discuss today. Before I get started, I should probably say to those of you who aren't sure where you stand on this topic, or perhaps you know where you stand and you're wholeheartedly thinking you're just going to disagree with me, and so you're going to try to poke holes in anything that I say, and that will probably start with saying, I have no, who am I? Who am I to talk about the topic of abortion and the Constitution, and why would my opinion or any statements I have be worth anything to you? Thanks, Mike. I've been struggling with how to tell you why you should listen to me on this subject, but I've been nervous about doing that. Well, the obvious reason why you should listen to me on this subject is because we're going to be discussing the constitutionality of abortion. And, well, I'm a constitutional attorney, so I guess that kind of makes me someone that has a stake in the game, so to speak. But on a personal level, this is also something that has come into my thoughts and been something that was discussed in my life many years ago. When I was younger, my parents got divorced, and I was the only child that my mother has ever had, but I'm the only child between my mom and my dad. And when they got divorced in the 80s, I ended up living with my mom in Florida for many years and spent time in the summers and holidays with at my dad's house in Michigan. I moved to Minnesota with my dad and stepmom and step siblings, and things were just really rough. Things were rough when I lived with my mom. Things were rough when I lived with my dad, and I didn't really have a ton of support. So I decided I would do whatever it took to graduate from high school early so I could be on my own officially and live in the college dorms. So by 16, that's what I did. Completing college classes, even a law school class, and entering college at an age where some other universities told me I would be too young to succeed. Well, unfortunately, that also left me on my own to deal with some of those tough life situations. And by 19 years old, being alone in college, far away from any friends and family, I found myself unexpectedly pregnant and not sure what to do. I had some significant guidance, if you will, from at least one side of my family to have an abortion, because, well, I was never going to be able to finish college if I kept my child, and I certainly wasn't going to be able to go to law school, which was always my dream. And so that was a decision that I had to personally discuss and think about and figure out. And being raised by the very liberal side of my family, I grew up believing that abortion is a right. It's part of a woman's right, and no rich old white guy, aka the Republicans, as I was taught to believe, had a right to tell me what to do with my body. And so that's where I stood in the terms of what I thought was, the right thing to do for everyone. Somehow, though, when faced with that choice and hearing my own mother tell me I wouldn't be able to finish college if I kept my baby, wouldn't be able to go to law school if I kept my baby, let alone start my career as an attorney if I kept my baby. I was devastated, but somehow I just knew that that wasn't really an option for me. And I kept that general philosophy that it's still every woman's right to choose, et cetera, for many years, even into being married to Mike. Well, I can tell you that unexpected pregnancy when I was 19 years old resulted in one of the best things in my entire life. My son, Alex, who's now 18. And although, as many of you who have parented teenagers can understand, I am super glad that he is now officially a legal adult and I am no longer legally responsible for the choices he makes. He's my baby. And I love him. And I am so glad that I chose to go against what was being recommended for me. Now, I don't tell you that to make this all about me or to say that because that was the right choice for me, that is the reason why it has to be the right choice for everyone else. No, I tell you that to give you an understanding of my personal journey so that you can understand it's not like I was just raised thinking this and I was always, the strong conservative. And so really I have no leg to stand on in having this discussion in the first place. Farthest thing from the truth. In fact, our old pastor reminded us when we saw him a couple years ago that when I met Pastor Kelly in Belding, Michigan, that I was a very strong advocate of a woman's choice and, proponent of the right to abortion. And it wasn't until we lost the baby before Emma that God was finally able to open up my heart to the truth and be able to see things for what they really were. So again, I'm just telling you this to give you what my background is in starting this conversation with you. So without any further ado, in case you didn't read the description of today's video or didn't see the commercial for it yesterday, today's topic is about abortion. Is it constitutional? What are the constitutional issues revolving around that? And quite frankly, let's start with why should you care right now? Why should this be a topic that we're talking about now when it's been a hotly debated topic for decades? Well, first, I want to point out that this week is Easter, and it's a time where we celebrate the resurrection of Jesus and the eternal life that we can find through him. Eternal life. life is something that is taken away when an abortion happens. So this is the time to have that discussion. But not only that, let's look at what's happening on a nationwide level. The newest United States Supreme Court confirmed nominee is Ketanji Brown Jackson, who during all these confirmation hearings and things of that nature was quoted as saying that Roe and Casey are the settled law of the Supreme Court concerning the right to terminate a woman's pregnancy. So, in other words, the newest United States Supreme Court justice is sharing that it's her firm belief and understanding that the U.S. Supreme Court made the federal law that women have a right to an abortion. So, what about Michigan? Why would this be relevant to a vast majority of you that are watching this from Michigan? The Michigan governor, Gretchen Whitmer, filed her newest case in Michigan relating to rights of the people in Michigan state courts last week, less than a week ago. She filed this case to supposedly protect the right to abortion, specifically asking the court to, number one, declare that the due process clause of the Michigan Constitution protects the right to abortion. Two, declare that Michigan statute 750.14 is unconstitutional as violating the due process clause of the Michigan Constitution, and to declare that the MCL 740.14 or 750.14 is unconstitutional because it violates the Equal Protection Clause of the Michigan Constitution. And therefore, she's asking the court to enjoin or permanently stop specifically the prosecutors in the 13 counties that she named from enforcing that statute, MCL 750.14. So, I see there's a lot of comments through Facebook and YouTube and whatnot so far, but I am not ignoring them, but I'm going to get to those in a minute. I got to get this discussion up and running. And I think if I'm reading some of, like Joe, I'm seeing some of your comments about forcing people to do something. I really hope that you're going to listen to this whole thing. And then at the end, let me know if you still have the exact same conclusion, or if what I have said has caused you to think about it from a different perspective and perhaps lead you to a different conclusion. So, in looking at this topic, why don't we look at this claim that abortion is as a right, is a settled point of federal law. There's problems with that, right, settled, and law. First of all, case precedent is not law. Now, we've done many videos on this, but we'll just very briefly reiterate that law is something that comes out of the legislative branch of government. It is a undeniable legislative power. And that power is given to Congress at the U.S. level and state legislatures at the state level. If you look at the U.S. Constitution, Article 1, Section 1, and then Michigan State Constitution, Article 4, Section 1. Now, if you're in another state and you are trying to think of if this conversation is going to be applicable to you in your state, yes, 100%. Some of the exact citations are obviously going to be different, but this applies all across the U.S. But just note that with the case that Governor Whitmer has brought, I have a lot of Michigan citations in this discussion today. And as far as the separation of powers, it's not simply a doctrine. Now, at the federal level, I guess you could say it's a doctrine because it's implied. It's common sense. If you have Article 1, Section 1 giving legislative power to the legislature, Article 2, Section 1 giving the executive power to the president, and Article 3, Section 1 giving judicial power to the state or the U.S. Supreme Court, well, that's dividing those powers. And if you look at the Declaration of Independence, which I have right there, then it's dividing those powers, because if you put all those powers or more than one of those powers in one basket, so to speak, you're creating the grave potential for tyranny and total loss of freedom. So it's an important, undeniable doctrine, if you will, from the U.S. Constitution perspective. But the Michigan State Constitution, it's not a doctrine. I don't care what the state Supreme Court justices have said. I don't care who says anything else. Anybody can read. And our state constitution, Article 3, Section 2 of Michigan, clearly says separation of powers, and that you cannot be in one branch of government exercising the powers of another branch of government. So, case precedent is not law. What about this right being settled as a matter of law? Well, the nationwide history, if you look at, and what's funny is that Governor Whitmer has no problem pointing out the history, basically, all across the U.S. She points out, or she claims, that abortion criminal statutes, making it a crime in some way to have an abortion, is coming out of the notion that women who try to take control of their reproductive health care are actually domestic subversives. I can't even talk today. And she took issue with the statutes in the past from, the 1800s that imposed a greater penalty, manslaughter, for an abortion with a certain type of pregnancy, and an even greater penalty, murder, if an abortion resulted in the death of the mother. She takes issue with that. But in taking issue with that, she talks about, let me see here. She states, this is in her complaint, to protect this right, as she calls it. Between 1860 and 1880, at least 40 anti-abortion statutes were passed in the United States, 1800s. Most of them criminalizing abortion at any point during gestation, at any point. By 1900, every single state had enacted an anti-abortion law, except for Kentucky, where state courts outlawed abortion. So, that is the nationwide history. Briefly about the Michigan history, she says, this is again Governor Whitmer, during that same time period in the 1800s, Michigan already had the abortion statute, almost word for word is what it is today. It was put into place in 1846. And Governor Whitmer says that during the period of 1860 to 1900, the Michigan legislature amended the criminal abortion statute to put the burden on the healthcare provider, the doctor, to prove that an abortion was necessary to save the life of a woman. And she then says, by 1931, the Michigan legislature amended abortion statutes again, this time to stay up with all of the other states and their changes in criminal statutes regarding abortion. In fact, one of these changes in 1931 changed the definition so that it was now, specifically in Michigan, no longer just a crime to instigate, to cause an abortion of a quickened child, as I'll explain in a minute, but now both unquickened and quickened. So what does that mean? Quickened means, according to Gretchen Whitmer, the point at which a mother can feel movement in her body. She can feel fetal movement. And so she makes the distinction that the initial statute in 1846 was specific to quickened children, where the child had already had greater movement that a woman could detect. In fact, this is how she defines it. Oops, and then I picked there it is. Quickening is the point at which the mother first perceives fetal movement, and it typically takes place midway through gestation. Okay, so she's pointing out by 1931, nearly 100 years ago, the Michigan legislature, along with many other states, specifically identified in their criminal statutes that it was illegal to kill an unborn child, no matter what stage of the pregnancy a woman was in. Okay. So, she then points out that, well, before I go into Michigan history, or where we're at currently, the United States Supreme Court, United States federal law, right? Well, although Justice Ketanji Brown Jackson claims that Roe is a settled point of law, guaranteeing this right to terminate a woman's pregnancy, Gretchen Whitmer actually argues the exact opposite. She says this is far from being a settled point of law, and she describes that all throughout. For example, let's see here. The right to abortion under the U.S. Constitution recognized in Roe has been gravely undermined over 50 years of federal court litigation about abortion rights. Since Roe, the Supreme Court has weakened the standard by which federal courts assess restrictions on abortion and upheld numerous restrictive laws limiting access to what she calls reproductive care. She says it is unclear where that leaves MCL, the Michigan statute 750.14, as a matter of federal constitution law, since the Michigan Supreme Court case on point based its decision upon the federal right to abortion, as talked about in the Roe v. Wade case. So she also then points out that after the Roe v. Wade case, the Supreme Court of the U.S. approved of notification requirements for minors who are seeking abortions. In the Planned Parenthood v. Casey case in 1992, Governor Whitmer points out that informed consent statutes are okay. Statutes requiring a 24-hour waiting period are okay. And of course, the parental consent statutes are okay. She then talks about the Sixth Circuit Court of Appeals, federal courts, talking about them upholding a requirement that doctors provide women with certain information at least 48 hours prior to an abortion, except in cases of medical emergency. And she basically concludes this argument by saying, in recent years, the steady drip of specific abortion restrictions upheld by the U.S. Supreme Court has substantially impaired this federal right to abortion. The U.S. Supreme Court has also cast doubt on whether the federal right to abortion is settled law by indicating a willingness to overturn this precedent. And she goes into specifics about that. So nationally, the history is that every state had an anti-abortion statute, just like every state has a law against murder. She then talks about how, nationally speaking, that the cases have kind of gone all over the place, that it's no settled point of law. Talks about in Michigan, the history and how the restrictions have always been there, but how they have gotten stronger. In fact, she then talks about the statutes today. So you have the MCL 750.14 that makes it a crime for an abortion to take place. But then you also have MCL 333.17015 I'm pretty sure that one is a parental notification statute. I forgot to write down. Nope, that one isn't the parental notification. Oh, that one is the requirements on doctors. Sorry, give me a second. There is so much here. I was trying to give you enough detail without overlooking something, and I overlooked writing down what that statute actually was specifically for. Well, at any rate, I don't have it right in front of me, but you guys can look it up if you would like to. It is MCL 333.17015, subdivision 3C. So then Gretchen Whitmer, points out that MCL 722.903 and .904 both talk about a minor's right to abortion only if there's written parental consent or the minor has gone to court and received permission through court order. She then talks about MCL 333, which is part of that public health code we've been talking about. MCL 333.20115, subdivision 2, which says that any outpatient facility that performs 120 or more abortion procedures per year must, and publicly advertises outpatient abortion services, must be licensed as a freestanding surgical outpatient facility. She's taking issue with that. But yet she's saying abortion would be safe without this requirement. She then says that each freestanding surgical outpatient procedure in MCL 333.208211, yet another Michigan statute, requires these freestanding surgical outpatient facilities to have an agreement with a nearby licensed hospital to provide for emergency admission of patients if there's something that has gone wrong. Because guess what? Abortion is not just the safe thing. It's not like getting a tiny cyst removed from your arm or something like that. But even that, of course, there's complications at times. So there are and have been laws on the books in Michigan for quite some time prohibiting outright abortion. And then when the federal U.S. Supreme Court got involved and created this precedent, then statutes got more specific and regulatory about how things are performed and under what conditions. So meanwhile, the one 750.14 that started it all is still on the books. Okay. In fact, the current status of this case, of this topic in Michigan courts, Governor Whitmer said it best in here. Of course, I have 5,000 things highlighted throughout these documents, and I can't seem to find the exact thing. But as she said in her documents, the Court of Appeals, the Michigan Court of Appeals, outright declared that the Michigan Constitution does not provide some sort of right to abortion. Then she pointed out that the Michigan Supreme Court, when that case was appealed, the Michigan Supreme Court denied to take that case. In general, that gives the notion that what they did below is correct. And there's no need for the court to get involved. Now, I didn't read the order denying the court taking on that case, but you better believe I will amongst all these hundreds of other things I now get to read. So that's where the laws stand in Michigan and across the U.S. and the case precedent across the U.S. and specifically in Michigan. So she's saying that the only way that Michigan so far has had this declared right to abortion in the state of Michigan is through federal law created by the Supreme Court. And that federal law has been changing significantly. And so she wants greater protections to make sure that there is a declared right to abortion in the Michigan Constitution. That is what Governor Whitmer is requesting. So let's look at this, though. She's if we want to finish rounding out the point, though, about settled law, right? As our newest United States Supreme Court Justice, Ketanji Brown Jackson, declared that this right to abortion is a settled point of federal law. Let's look at settled points of law. So if we have to follow this law, because it's settled and it's been done by the U.S. Supreme Court, let's take for a second, let's pretend the Supreme Court is allowed to make laws, okay? Let's pretend for a second that this is settled. It's not in dispute. And it's just always been the case that there's been case precedent saying, nope, you cannot ever regulate abortion, every woman has a right to abortion, etc. Let's look at what binding ourselves to case precedent does, and perhaps gain an understanding of why it is the legislature that has been given the legislative authority and not the courts. Let's look at the Dred v. Scott case. You guys know about this one. It's from 1857. This, according to people other than me, is stated to be hands down the worst Supreme Court decision ever. And it held that Black Americans, whether free or a slave, could not be considered American citizens based on the color of their skin, and could not claim the rights as citizens in court. In fact, it wasn't until after the Civil War, and we got the 13th and 14th Amendments, that that point of federal law was overturned, was stopped. So until that point, until a constitutional amendment, the U.S. Supreme Court said that someone who has a different skin color than we do is not allowed to be considered an American citizen and cannot come into court as a citizen and expect to have rights as a citizen. Are we supposed to follow precedent just because it's precedent? Buck v. Bell. No, I'm going to come back to that one because that actually pertains a lot to what we're talking about here. What about Plessy v. Ferguson? You guys have heard this too. Growing up, I'm sure you did. 1896 is when that case was decided. Of course, that is the court's famous separate but equal ruling. And of course, it was the case where the court upheld states segregating public facilities according to race. So all those years later, the court was still, the U.S. Supreme Court was declaring that you are not a human being worthy of receiving equal opportunities, equal ability to exercise your God-given liberties if your skin color is different. In fact, that case stood as case law and precedent for 58 years until being overturned. So the fact that it was nearly 60 years as precedent, wouldn't you consider that to be binding precedent, a settled point of federal law? Yikes. Of course, the civil rights cases. The civil rights cases in 1883 were striking down the Civil Rights Act of 1875. That law, the Civil Rights Act of 1875, was put into place to ban discrimination based on race in businesses and public accommodations. But again, this decision to strike down the Civil Rights Act came from an 8-1 court. 8 justices said, no, Congress can't prevent non-governmental racial discrimination. So it took over 80 years for the court to change its mind on this and make another federal law on that point. Over 80 years. For over 80 years, the court was perfectly fine with this 8-1 majority saying that Congress can't make any laws that punish racial discrimination in non-governmental settings. Even though the equal protection statute or part of the Constitution clearly is equal protection of the laws. What else could that mean? Oh, yeah, that's right. Separate but equal. Yeah, okay. Oh, goodness. We have Hammer v. Dagenhart from 1918, case that most people don't know about. The U.S. Supreme Court ruled that Congress could not ban child labor. So even though they said that Congress had the right to regulate gambling and other vices, Congress, according to the U.S. Supreme Court, had no right to keep children out of working in mines or factories because that was something only states could talk about. And some of you may still agree with that, but for those of you who don't, are you also on the same side of saying that this abortion issue is a settled point of federal law? Let's think about this. Kelo v. City of New London. This is 2005, not that long ago. The U.S. Supreme Court allowed taking land from one private party to give it to another private party under the takings clause. That's totally okay. Totally okay because, in fact, what happened here is they took Suzette Kelo's land and they gave it to a private developer and said, well, it's part of a comprehensive redevelopment plan for the city, so it's totally okay. What? But that's the U.S. Supreme Court in 2005. Is that a good decision, a good point of federal law that we're bound to follow? Oh, great stuff, I tell you. What about the Exxon shipping company versus Baker in 2008 when that decision finally came down? So you guys, obviously, if you're at least my generation, you grew up hearing about the Exxon Valdez oil spills, one of the greatest environmental disasters of all time. And there were years and years of litigation. Through a trial, Exxon was finally held responsible for its negligent issues, resulting in that, catastrophic environmental disaster. And they were given a $5 billion damage payment that they had to make. They had to pay $5 billion. But when Exxon appealed, the United States Supreme Court said, no, they can't do that. So you only have to pay $500 million in damages. Something that actually damaged environments worldwide, which you would think the liberals would be all up in arms about. They're okay with whatever the Supreme Court says. And the Supreme Court said that in those situations, a company like Exxon is not liable past a piddly fraction of what a trial court determined would be appropriate. In fact, not only that, but it was the next 2 days after the decision came out, Exxon's stock went up $23 billion. Yeah. Is that a settled point of federal law? I'd love to hear how that would be the case. Okay. Bowers v. Hardwick, 1986. In 1986, it was the U.S. Supreme Court that upheld a Georgia statute that criminalized gay and lesbian sexual relationships. Okay, the U.S. Supreme Court said, yes, it's okay to call those activities criminal in nature and to prosecute for them. I would think every liberal supporting the abortion argument would have a problem saying that, well, this case is from decades ago. It's a settled point of federal law that we have to follow, that gay and lesbian sexual relationships are criminal. I don't think they'd say that. Now, that case was eventually overturned decades later, but There are states that still have on the books anti-sodomy statutes. So, and the case that I would pronounce wrong if I said it, Korematsu, I'm totally pronouncing that wrong, versus the United States. It was a 1944 case. During World War II, 100,000 Japanese Americans were forcibly detained in internment camps under an executive order. The order applied regardless of citizenship, and when a case was brought by a second-generation American with Japanese heritage, the U.S. Supreme Court ruled against him, saying it doesn't matter. It's okay to forcibly detain someone in that situation. And in fact, many judges to this day would agree that that was the right ruling and would say that the same thing could apply today as it did then. In fact, Justice Scalia even remarked that you are kidding yourself if you think the same thing will not happen again. So, should we really always follow what the U.S. Supreme Court says? Whatever side of the political spectrum you're on, I would think there's something in there in all that precedent that would tell you, no, that would be horrible. Okay, so what about an abortion? Well, let's start with what is an abortion. Let's keep it simple. Merriam-Webster, online dictionary, checked it out again today. It clearly says that an abortion is the termination of a pregnancy after, accompanied by, resulting in, or closely followed by the death of the embryo or fetus. It breaks it into three separate kinds. So it's talking about, first, a natural miscarriage could be considered a spontaneous abortion, medically speaking. We're not talking about that here. The third thing it lists is a miscarriage in a domestic animal due to an infection. We're not talking about that here. But secondly, and what's applicable here is it's talking about an induced expulsion of a human fetus. That's what we're talking about here. So it's talking about the death of that embryo or fetus. You can't have death if you don't have life. So whose rights are involved in an abortion? You have the mother's rights. Despite what the left says, the child's rights are implicated. The state and society, there's rights implicated there. And often overlooked, the rights of a father. We do, after all, have a right to parent our own children, and that is a settled point of law in federal and state jurisprudence. So what about the child? Can a unborn child have rights? Where do we look for that answer? Well, first of all, we should look to God's word. God is ingrained into the very fabric of our state and federal government. Now, before you individuals who think that there's this huge thing of church and state get all riled up, let's look at that. Where in the U.S. Constitution or state constitution are the words separation of church and state? Still waiting. Oh, yes, that's right. They don't appear anywhere in the U.S. or Michigan constitutions. But do you know what words do appear on point in the U.S. And Michigan constitutions? We, the people of the United States, in order to establish justice and a few other things, including secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution. Blessings of liberty. That's in the U.S. Constitution preamble. In the Michigan State Constitution preamble, says it even a little bit more clearly. We, the people of the state of Michigan, grateful to Almighty God for the blessings of freedom and earnestly desiring to secure these blessings undiminished to ourselves and our posterity, do hereby ordain and establish this Constitution. Okay, back to the U.S. Constitution. Congress shall make no law prohibiting the free exercise of religion. Of course, that's in the First Amendment of the U.S. Constitution. Michigan Constitution, Article 1, Section 4, every person shall be at liberty to worship God according to the dictates of his own conscience. And then let's round it out. Michigan Constitution, Article 8, Section 1, and other states have similar provisions. Religion, morality, and knowledge are necessary to good government and the happiness of mankind. That is written into the very wording of our state constitution. So God is ingrained into the very fabric of our state and federal government. So what does God's word say on this point? Luke 1:41 reminds us that a child in a mother's womb is a baby. Job 3:16 recognizes a stillborn child, a baby who dies from natural causes in the womb, is just like an infant who never saw the light of day. Jeremiah 1:5, before I formed you in the womb, I knew you. Before you were born, I set you apart. I appointed you as a prophet to the nations. God knew us before we were born. We existed before we were born. Psalm 22:10 goes further to say, from my mother's womb, you have been my God, recognizing God knows us and claims us even before we are born. Jeremiah 20:17, for he did not kill me in the womb, with my mother as my grave, her womb entombed forever. So we recognize even there that when an unborn child ceases to exist in the womb, it is killing that unborn child. Of course, Exodus 21:22, if people are fighting and hit a pregnant woman and she gives birth prematurely, but there is no serious injury, the offender must still be fined. Birth. Unborn children. Unborn children have the right to stay in the womb and develop. And those who get in the way of that are to be punished. Exodus 20:13 and Deuteronomy 5:17. You shall not murder. And of course, in Deuteronomy 30, verse 19, I have set before you life and death, blessings and curses. Now choose life so that you and your children may live. I think it's pretty clear what God's word says on that point. But even world-renowned universities like Princeton, at the moment the sperm cell of a human male meets the ovum of a female and the union results in a fertilized ovum, which is a zygote, a new life has begun. Okay, what about the government? Does the government have a say on this? Well, the National Center for Biotechnology Information, which is a part of the United States National Library of Medicine, a branch of the National Institute of Health, a lot of acronyms, a lot of layers, but federal government says that the embryo has the same nature. In other words, it is the same kind of entity. This is not paraphrasing. This is a direct quote. From fertilization onward, there is only a difference in degree of maturation, not in kind, between any stages from embryo to fetus, infant, and so on. Federal government makes that clear. That's not something from the ancient times. That's something from 2009 that was still accessible on the federal government's websites. So there is no difference whether a person exists or not after the fertilization of the egg, after conception. The only difference, according to the federal government, is the degree of maturity between embryo to fetus, fetus to infant, infant to toddler, teenager, adult, senior. So what rights are involved in this abortion topic? Health and life, the right to health and life, that of the mother and of the child. There's a claimed right to privacy on behalf of a mother. For example, Gretchen Whitmer comes right out and says that abortion is a privacy right. There's the right of due process for the mother, but also for the child and for the father. And equal protection of the law is involved for the mother, for the child, and again for the father. So what about the mother? Her right to health and life. I'm not going to go into all the science and the medicine, etc., the psychology, but it is undeniable that women who have gone through an abortion have psychological effects and oftentimes outright trauma because of that abortion. Physical effects. Governor Whitmer's complaint that we talked about earlier goes into that, but minimizing it, saying, oh, there's not that many effects. In fact, she equates abortions to colonoscopies, plastic surgeries, and adult tonsillectomies. She then states the risk of death subsequent to legal abortion is just a fraction of the risk of death for childbirth. And she says it's only 0.7 people die per 100,000 compared to 8.8 people per 100,000 dying through childbirth. But what she forgets is in 100% of abortion cases, where the abortion is completed, the baby dies. It is fatal to at least one person in that situation. It may also be fatal to the mother. So there is a risk of death for the mother. The child has that right to life. That's why there's an organization called Right to Life. I mean, it's something we maybe hear and go, oh, that's just political. But no, the child having a life has a right to keep that life. And their health, well, let's look at it this way. A lot of the same people arguing for abortion are the same people that argue for really strict child protection laws where the government can come in, sweep in, and take your kids away from you if you're not parenting your children good enough. And to a lot of them, and don't get me wrong, I've served as a lawyer guardian ad litem for children in abuse and neglect cases in 2 different states, and I'm a huge advocate for child well-being and safety. So I'm not saying that that is not a need, but in cases where parents are not vaccinating their children, or where parents are not requiring their children to wear masks in public settings, which is obviously a more recent thing, or some of those things where children are being homeschooled instead of educated in the public school system. Sometimes, for any of those reasons, child protection workers will come in and take children and say, oh, you can't have your child. Your child has the right to be educated. Your child has the right to be immunized or receive proper medical care. Your child has the right to be healthy. Health starts with life. If there is no life, there is no health. Okay, what about the state? Well, I'm just going to leave it at this. The state does have an interest in protecting the health and life of children and mothers. But the easiest place to find that would be Article 4, Section 51 of the Michigan State Constitution that says the legislature shall pass suitable laws for the protection and promotion of the public health. Well, if people are allowed to kill others, I'm not sure why we're bothering with protecting health. Privacy. What about that right to privacy? It is claimed that for a mother, abortion is a privacy right. In fact, Gretchen Whitmer even talks about the right to an abortion in terms of unenumerated rights that are in the U.S. and Michigan constitutions. In fact, let me see here. Here we go. Paragraph 82 of her complaint from last week. This is from last week. Governor Whitmer submitted to the court the right to privacy for women in the context of abortions is also guaranteed by the unenumerated rights clause, which protects rights retained by the people that are not otherwise enumerated in the Michigan Constitution. Article 1, Section 23. Then she goes on to explain, if you look at the official record from the 1961 Michigan Constitutional Convention, it states that Section 23 is taken, quote, taken from the 9th Amendment to the U.S. Constitution, end quote. And she also explains, this is Governor Gretchen Whitmer, that, quote, Section 23, the unenumerated rights clause in the Michigan Constitution is, quote, it recognizes that no declaration of rights can enumerate or guarantee all the rights of the people. So in case any of you have been doubting me on the unenumerated rights, as I've been talking about them in every other video where we've been discussing any rights at all, seems like Governor Gretchen Whitmer agrees with me on that point. So she then says that the right to bodily integrity, a component of the right to privacy, protects against compelled intrusion into the human body, which is a U.S. Supreme Court case from 2013. Funny thing that they say we have a right to privacy, and that this right to privacy includes a right to bodily integrity. Okay, but we can mandate masks and inhibit breathing and things of that nature. And that this right to bodily integrity includes the prohibition against compelling intrusion into the human body. Gee, that sounds like a topic of jabs that we've discussed further in other videos that get banned from major media platforms. Hey, these are the words from Governor Gretchen Whitmer. So if the right to bodily integrity exists and is covered by the Michigan Constitution, I'd say I agree with that, don't you? But what's good for the goose is good for the gander. A right to bodily integrity that the mother has certainly exists for the other lives at stake, including the unborn child. So let's look at that and develop that topic a little bit more. And there is a ton more that I wanted to share with you all on this, but it's obviously going to be way too much for one episode. So this is just an overview. But due process of law, that's another right that's brought about by the discussion on abortion. Of course, the Fifth Amendment to the U.S. Constitution and the 14th Amendment, Section 1 of the U.S. Constitution, guarantee that no person shall be deprived of life, liberty, or property without due process of law. No person. And of course, the Michigan Constitution, Article 1, Section 17, no person shall be deprived of life, liberty, or property without the due process of law. So who is involved here where due process rights are being deprived in some way, depending on what the government does? The mother, as Gretchen Whitmer argues, the child, and the father. Simply put, we have that right to parent our own children. And that it could be a topic for a whole nother discussion. But if we have the right to parent our own children, then certainly if a father sees that his child is about to be killed, if his child's life is about to be purposely terminated, then as a parent, that father has the right to do something about that. And so if the government is saying, if the court is saying, no, it's all good ahead of time, before he even has a day in court about it, he's certainly being deprived of his rights, his fundamental rights to parent his child. But of course, and I'm not denying that a mother has the right to due process. Sure, she does. And so does a child. A child is a life. So once a child is a life and a mother is a life, and you have two lives, and the mother is saying the interests of my life are contrary to the interests of this child's life, that's the whole purpose of government, right? Literally. I get where someone earlier was saying, I don't like any kind of laws where we're telling other people what to do. But if you really stop and think about it, that is the whole purpose of living together in a society. That is literally the whole purpose of our US and Michigan constitutions, right? We created government to protect our individual liberties, so that when I'm out there exercising my individual liberties, I'm not infringing upon your rights to exercise your individual liberties. So I have the right to build whatever I want in my own yard. Licensing, permitting, all that stuff aside, it's a whole other topic for another discussion, right? But I have the right to build whatever I want in my own yard. Does that mean that I can go and steal your building supplies to put that building in my yard? Is my right to build whatever I want in my own yard, on my own property, does that enable me? Does that give me the right to take my neighbor over there and the other neighbors next to him and enslave them on my property and force them to build my house for me free of charge because that's what I want? I have the right to build a house. I can do it whatever way I want to. No. I mean, it's literally the same thing. We have government to protect our individual liberties so that when I'm exercising my individual liberties, I'm not intruding upon and trampling your individual liberties. It's not called equal creation and restrictions of laws. It's not called equal regulation of the people. It's called equal protection of the laws. Because the laws are supposed to be there to protect our individual liberties. And everyone has that right to that individual liberty, life, liberty, and property. So a mother and a child, if their rights are at odds, the mother's right to control what's happening to her body doesn't override the right to kill the unborn child. It's not how it works. It's not how it works in our Constitution, in our state laws. But we are certainly denying equal protection of the law to children. And how many times have you even heard about the topic of fathers' rights on the issue of abortion? You don't really hear about that. They are certainly being denied the right to equal protection of the laws. Cruel and unusual punishments. Well, both our U.S. and state constitutions say that cruel and unusual punishments shall not be inflicted. 8th Amendment to the U.S. Constitution and Article 1, Section 16 of our state constitution. Ending one's life is not acceptable at all. It's murder, right? If you end someone's life, it might be manslaughter, it might be murder if it was, negligent or intentional or whatever, but it is criminal to end one's life unless it's in self-defense or It's a punishment of a particularly heinous offense. So if someone comes into my home and they try to attack me and they're trying to kill me and rob me, and I take my gun out and I shoot them, that's okay under the law because I have a right to defend myself. And God's okay with that too. You're not out there murdering people. You're literally trying to stop someone from taking the life that God has commanded us not to take. So what about the particularly heinous crimes? Well, those who have been found guilty through due process of particularly heinous offenses, our country has determined can be put to death. Now, I've done some significant research on the death penalty, and I actually think the death penalty is unconstitutional. I certainly think it violates natural law. But let's look at the Michigan State Constitution. It says in Article 4, Section 47, no law shall be enacted providing for the penalty of death. You cannot kill someone, even for committing one of the most heinous, horrible crimes that you can think of. You just can't. So, one other right that is often not talked about in this topic is the right to be free from bills of attainder. Now, it's been quite some time since I've talked about this particular right, and most people go, huh? But, by the way, I realize that facial expression is going to naturally be the thumbnail that YouTube and Facebook choose when my video is displayed later. It's going to be great. But anyway, the right to be free from bills of attainder. What is a bill of attainder? Looking at Black's Law Dictionary, it's the easiest way to explain this. It is a special legislative act that imposes a death sentence on a person without a trial. So where the government imposes a death sentence without a trial, allowing any class of persons to be murdered or have their life terminated without allowing them a day in court to defend themselves. That's literally a bill of attainder. And Article 1 of our U.S. Constitution, Section 9, Clause 3, no bill of attainder shall be passed in a nationwide sense, but it was important enough that the U.S. Constitution also has it in Article 1, Section 10, Clause 1, that no state shall pass any bills of attainder. And in fact, Michigan Constitution, Article 1, Section 10 says that no bill of attainder shall be enacted. Yet, if we are to recognize that there is this right, government protected right to kill the unborn and not provide them a day in court, at least, before that happens in each and every case, that is a bill of attainder that is expressly prohibited by the U.S. and Michigan constitutions. So, man, is there a ton in here I would love to share with you? Absolutely. If you look at the arguments of the Supreme Court in Roe v. Wade, there's so much. I have like oodles and oodles of pages highlighted. And there's just so much. It would take quite a long time. I love this one from Gretchen Whitmer. Abortion is a medically safe and necessary procedure. Not sometimes. Not in the life, when the life of the mother is imminently in danger or anything like that. That's not what she's talking about. She's saying, in general. Well, as Gretchen Whitmer says, the Michigan Supreme Court in 2010 declared that the Equal Protection Clause requires that all persons similarly situated be treated alike under the law. I agree, Gretchen. I agree that every single human being, every single life has the right to exist and not be deprived without due process of law. And certainly At the very least, that means, well, it should mean a trial of some kind. So wow, there are a lot of comments. I'm going to defer to Lori really quick to see if, sometimes there's just conversation back and forth. Lori, can you please let me know if there are questions or comments that are in all of the comments on the different social media platforms that I have not addressed already at this point? While she is having a second to answer me on that, I do want to remind you that we do have all those other constitutional segments, those Constitution-related segments. Tomorrow, you have your Wednesday's way to get involved. Thursday, we're going to do the Constitution segment recap. I have no idea how I'm going to do that in less than an hour, but hey, we're going to try. Friday is going to be our freedom fighting tools. Saturday, a look at this week's freedom fighting Restore Freedom goodie. Sunday is, a little bit more in-depth look at the biblical insight on this week's topic, which I normally wouldn't be bringing back into this whole discussion, but this is a one in the same. They're in tandem, and you can't have one conversation without the other. Let's see. Lori says a lot of questions were answered, and she's asking somebody if there was a question that I did not get to that she has overlooked to go ahead and post it now. So please do take a look at that. I would ask you to fill out the survey. Now, if you get our newsletter, it was a link in the newsletter. If you don't, it's been posted on all of our social media platforms. The survey is simply asking, it'll honestly take you 30 seconds or less. If you think that I should participate in the Iron Pig case that is in front of the Michigan Court of Appeals right now, if you think that I should file an amicus brief to argue the issues of whether the public health code orders that carried on the EOs from Whitmer from 2020, if that part of the public health code is unconstitutional and must be stopped. That point has not been argued yet in front of the Michigan Court of Appeals, despite the case being presented to them in February. So it looks like I don't see any other questions being posed. If you do have an opposing thought or viewpoint and you have listened to what I've had to say, let it digest. I'd love to have a dialogue with you and see if we can come to a common ground on this. Because again, I'm not someone who's a lifelong conservative who's always believed this way and grew up thinking this way. Far from the opposite, or quite the opposite, I should say. Far from that is true. And it's not just my immeasurable love for my 18-year-old son, Alex, that causes me to take this stance and provide this discussion today. It's the truth and my love for the Constitution that also brings this discussion to us today. So I may very well also have out there a petition, or not a petition, but a survey asking you if you think I should try to get involved as an amicus in this lawsuit that the governor has brought. She's filed it against 13 prosecuting attorneys where the state's, I believe it's 27 abortion clinics are located within. So she's naming each of those prosecuting attorneys as defendants. And she's pursuing this in the circuit court in Oakland County. And the court file number, for those of you who want to look it up, is 2022-193498CZ. I find interesting that she not only has the Michigan Deputy Attorney General representing her in this request, but also 3 assistant attorneys general and 5 special assistant attorneys general that she is bringing in from New York, who are not licensed Michigan attorneys, as well as 2 attorneys who she claims are special assistant attorneys general that she is bringing in from Washington, D.C., who are not licensed Michigan attorneys. She's bringing the big guns to this fight. So I do appreciate your thoughts on whether I should participate in this case as well. And last I saw, none of the prosecutors have responded, although it's been less than a week. So there is a little bit more potential that one of those prosecutors will fight this. All right. Thank you so much for hanging in there with me today. I appreciate your support, your prayers, your financial support, your words of kindness. I ask you to check out our other segments this week, especially my live via the internet presentation at the Patriots and Pancakes event in Holland, Michigan this Saturday at 11:30. I will be presenting via an online broadcast. But nonetheless, you'll have an opportunity to ask any questions about the topic I will share. I look forward to continuing on this journey, this fight for freedom with you. And I wish you all a wonderful afternoon. Thanks all. Have a great day.